Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Today, Chetan sir and me, we are here to discuss UPSC CSE Mains GS2 question paper. Polity, governance, social justice and international relations. 20 questions in total. From polity and governance, I would be discussing 10 questions. Chetan sir would be discussing 4 questions related to international relations. Later, Astha ma'am would be discussing 6 questions from the field of social justice. First up, if we analyze the question paper, it is mostly current affairs dominated. So the current affairs over the past couple of years, that has remained the dominant theme of this question paper. Let's look at these questions one by one. First up, question number 1, discuss the corrupt practices for the purpose of Representation of the People Act 1951. That's aspect number 1. Then analyze whether the increase in the assets of the legislators and or their associates disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. Now, you would know that Representation of the People Act 1951, this is the law which governs the entire conduct of elections in India. And it is this law which in its section 123 talks about various corrupt practices. For example, bribery is a corrupt practice. Undue influence, asking for votes in the name of religion or caste, that amounts to corrupt practice. But when we look at undue influence, listen to me carefully. Supreme Court has said, way back in Association for Democratic Reforms, that the voters have the right to know the antecedents of the candidates contesting elections. That is why in filing election affidavits, the candidates contesting the election, they have to reveal certain details. The educational qualification of a candidate, the amount of assets that he holds, the amount of assets that the spouse of the candidate also holds, and number of criminal cases pending. So all these aspects, you will have to have a disclosure. But does that mean analyze whether the increase in the assets of the legislators and or their associates, if there is a candidate contesting the election and the candidate also has an associate, for example, the election agent, if this election agent with the consent of the candidate is also doing something, corrupt practice, undue influence, then this candidate as well as the associate can be prosecuted for that. But does an increase in the asset of income of a candidate as well as the associate amount to undue influence? Only if, this is according to Lok Prahari judgment of 2018. It will amount to undue influence only if it is not disclosed, because non-disclosure of this asset by the candidate himself would amount to undue influence over the voters, and as such is a corrupt practice under Representation of the People Act 1951. But directly, this law does not say that an increase in the amount of assets of an associate would amount to undue practice, undue influence over the voters, unless and until it is led to non-disclosure under Representation of the People Act. That is what is the content of this particular question. If you look at question number 2, comment on the need of administrative tribunals as compared to the court system. That's aspect number 1. So you would know that it was the 42nd Constitutional Amendment Act 1976, which added Article 323 capital A in the Constitution, which talks about administrative tribunals. How are they? What is their need over regular court? The idea is to have specialists, because in tribunals, apart from judicial members, there are specialists as well. And then it will reduce the burden on the regular courts. So the idea is that these administrative tribunals, which will hear disputes, let's say CAT, the disputes related to a civil servant, whether related to promotion, any disciplinary action, instead of going to the regular court, you can directly go to the administrative tribunal. CAT at the central level, SAT at the state level, and Parliament has the power to create CAT. And through this mechanism, we ensure that since there are specialists also, the judgment or the ruling or what we call the award given by the tribunal would be well reasoned because of the presence of these experts. Because judiciary may not be, judges may not be experts in these domains. So we need the domain specialists to be part of these administrative tribunals. And it will reduce the burden on the judiciary. And at the same time, this award will be given, this ruling of the tribunal will be given. So speedy trial would be, speedy justice would be ensured. But then we also saw that there used to be a raging debate in the country that blatant tribunalization has reduced the jurisdiction of the high courts in this country. Because sometimes what would happen, the award given by the tribunal, you can appeal directly before the Supreme Court and you are bypassing the High Court, which primarily means one, listen to me carefully. If I'm a High Court judge, but I cannot hear cases related to environment because for that we have NGT, cases related to service matters, for that we have CAT. And if at all you want to appeal against these awards, you directly go to the Supreme Court. So you're bypassing the High Court. Then the same High Court judge would later on be promoted to the Supreme Court. And when I am promoted to the Supreme Court, I don't have the expertise in dealing with these service matters because I was never exposed to these matters when I was in the High Court, which primarily dilutes the authority of the High Courts. Then what happened? Tribunal Reforms Act was passed in 2021, which was also a subject of a lot of debate. In fact, this law is currently under challenge before the Supreme Court. Mr. Jairam Ramesh has filed a petition challenging the constitutional validity of the Tribunals Reforms Act 2021. Why? Because previously, you would know, an ordinance was promulgated by the president, and that ordinance was struck down by the court in the Madras Bar Association. And the court had raised certain issues related to age. So the age, according to that ordinance, was you should be a 50-year-old. The Supreme Court had suggested the age should be 40 years. Similarly, there was question mark over reappointment. There was question mark over the tenure. Tenure should not be 3 years. Tenure should be 5 years. On these grounds, these provisions in the Tribunals Reforms Ordinance were struck down by the Supreme Court. But the same provisions which were struck down by the Supreme Court reappeared in Tribunals Reforms Act. And that is why it is under challenge before the court. But the point is, in one of the judgments, Supreme Court has said that we should have a National Tribunals Commission, which will overlook and keep a check on all the tribunals functioning in this country. This National Tribunals Commission has not been constituted in India. And at the same time, for example, what is this question asking? The question is asking the recent reforms in the They assess the impact of the recent tribunals reforms through the rationalization of tribunals made in 2021. 12 tribunals were removed. But you have to also mention that this was done through the route of the money bill bypassing the Rajya Sabha. And at the same time, you need to keep in mind that, for example, FCAT, Film Certification Appellate Tribunal, it was junked. Instead, if you're not satisfied with the order given by the CBFC, with the certificate issued by the CBFC, you can approach the High Court directly. So the impact of this tribunal reform is the jurisdiction of High Courts is now back. Because if you're dissatisfied with the award given by the tribunal, instead of directly approaching the Supreme Court, you can directly approach the High Court. And at the same time, it makes justice accessible as well. Because, for example, previously, although the question is talking about, in the first part, administrative tribunals, but you can expand it because securities issue, security SEBI tribunal, you should have gone to the Mumbai Regional Center for Tribunal to get the award, which makes it inaccessible for other jurisdictions. Now, instead, you can directly go to the concerned High Court, and the High Courts are more accessible to the people than a tribunal. That is something which is a good thing from Tribunals Reforms Act of 2021. But the point is, comment on the need of administrative tribunals as compared to the court system. You have to list down the reasons. And remember, this is a 10-mark question, 150 words, so you can't write much as well. Write in points and be done with this.
Sarmad sir, these topics were always in news in recent times.
Always in news, yes.
The vacancies, the delay in filling up the positions.
Right.
Right?
Right.
Yeah.
Assess the impact of the recent tribunals reforms through rationalization made in 2021. Some tribunals were abolished, for example, FCAT. Similarly, you can directly approach the High Court now, but still at the end, you need to mention that in Madras Bar Association, in various other judgments, the court had recommended the composition, the creation, the establishment of a National Tribunals Commission, which has not been done. Let's look at another question. The question is on compare and contrast the president's power to pardon in India and in the United States. Are there any limits to it in both the countries? What are preemptive pardons? Again, as you were saying, Chetan sir, current affairs dominated. So you would know that just before he demitted office, the then president of the United States, Joe Biden, pardoned his son. And that was a preemptive pardon. Preemptive pardon in the sense, normally once you're convicted, then the president pardons you. Before the charges are filed, can you be pardoned? Yes. And that is what we call preventive pardons. Can only the US president issue preemptive pardon? No. Indian president can also do that. So under Article 72 of the Constitution, President of India has the pardoning power. But compare and contrast the president's power to pardon in India and in United States. In United States, we have seen a lot of misuse, where the President Donald Trump has also pardoned his associates or those who were considered responsible for the Capitol Hill riots. That abuse of Article 72, we don't see in India. But in India, the president does not do this on her own. She does this on the advice of the government through the Home Minister. And even then, the Supreme Court had said, whether you can quote Maru Ram judgment and various other judgments, that if the action of the president is malified, if the president is acting in bad faith, even then the court can come into. So there is judicial review of this pardoning power in the in Indian context, but that form of judicial review we don't see in United States. Let's look at another question. Discuss the nature of Jammu and Kashmir Legislative Assembly after Jammu and Kashmir Reorganization Act of 2019. Now, Jammu and Kashmir was a state with a special status under Article 370. But in 2019, the special status was revoked. Jammu and Kashmir was downgraded to that of a union territory. But union territory with a legislative assembly. And similar to the legislative assembly which we have in Puducherry. And in this legislative assembly, we saw the elections happening for the first time, and now we have an elected government. But it is not a state legislative assembly because there are some limitations. There are some subjects, for example, police, law and order, which is reserved for the lieutenant governor of the union territory. Briefly describe the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. Power is you can legislate on all matters mentioned in the state list except law and order and police. You can make a law on any item mentioned in the concurrent list, but even then, Parliament has the power to make a law. Because after all, it is a union territory, it is not a state. And a union territory is directly controlled by the center, is under the control of the center. But if you look at the composition of this Jammu and Kashmir Legislative Assembly, there are some seats which are reserved for women. There are some seats which are reserved for Kashmiri migrants. There are some seats which are reserved from those who have migrated from Pakistan-occupied Kashmir. So this was in the news. And since the election happened for the first time, and there is a raging debate on whether statehood would be restored to Jammu and Kashmir, the matter is before the Supreme Court as well. Supreme Court has asked this union government 8 weeks' time. Supreme Court has given union government 8 weeks' time to respond to this plea. That is why this topic was always in the news. Let's look at the Attorney General of India plays a crucial role in guiding the legal framework of the union government and ensuring sound governance through legal counsel. Discuss his responsibilities, rights, limitations in this regard. Article 76 of the Constitution talks about a constitutional post called the Attorney General for India. Although it is not Attorney General of India, this is where the UPSC has made a mistake. It is Attorney General for India, which is different from Attorney General of India. Be that as it may, plays a crucial role in guiding the legal framework of the union government and ensuring sound governance through legal counsel. We say Attorney General is the foremost law officer of the union government. He is the legal advisor of this union government. So whenever a government brings in a law or wants to take any constitutional decision, then the Attorney General is consulted, and his counsel is considered to be a very, very important counsel for the Union government. But if we contrast it with the British Attorney General is part of the cabinet.
Right.
But in India, Attorney General is part of the executive, but he is not part of the cabinet. But discuss his responsibilities and rights and then limitations.
Very straightforward question.
Responsibility is to advise the government, Union government, on all the matters on which the president will ask. One more interesting thing is, right now, which case is being heard by the Supreme Court related to Tamil Nadu case, Article 143, presidential reference. Who will represent the Union government when this presidential reference is being heard by the 5 judges of the Supreme Court? That individual is the Attorney General. That is his responsibility. And on any matter, the president may ask the Attorney General for his advice, for his legal counsel. What are his rights? He has some privileges. Whatever privilege is available to the member of the parliament, that is available to the Attorney General, which means you can speak in the parliament, you can participate in the parliamentary proceedings, you can be a member of a parliamentary committee without right to vote because you're not a member. What are the limitations? Limitations are you are not part of the cabinet. When you are not part of the cabinet, and this is something that I had discussed in the Conquer Mains examination as well, specifically, directly, should Attorney General be part of the Union cabinet just like we have in United Kingdom? So in a similar context, this question was asked. That is the limitation. Limitation also is that although you can give a legal advice, but it is for the government to either accept it or not accept it. Your advice may have persuasive power, but it is not binding on the Union government. So your limitation is you're not part of the Union cabinet, your advice may not be called in all matters, maybe the advice of the Solicitor General will be called. So that is something that we have to keep in mind. E-governance projects have built-in bias towards technology and back-end integration. Then user-centric designs examine. And if you notice this, Chetan sir, there was a very important judgment given by the court. Right to digital access is also a fundamental right under Article 21 of the Constitution.
Yeah.
Which
So this built upon the case Puttaswamy judgment.
Not Puttaswamy. There was one woman who was half burnt, acid attack survivor.
Right.
And she wanted to open the bank account for which KYC requirements are to be done. But if you know that when an acid attack survivor, she can't blink her eyes.
Yeah.
So iris scan becomes an issue. Biometrics becomes an issue. So this puts a limitation on these individuals, those who are disabled, those who have some issues with the eye, acid attack victims. How can they access these banking services?
Even Aadhaar, government public deliveries.
Exactly. Yeah. So for example, you have to do video KYC for which you are required to blink your eyes as well in front of the camera, which you can't do because you are suffering from some disabilities because of what has happened to you. So that Supreme Court has said simplify it because right to digital access is also a fundamental right under Article 21 of the Constitution. So our e-governance models, they're mostly focused on, let's say, back-end integration, interoperability, so public digital infrastructure whenever we focus on. But it is not focused on user-centric designs. Making it more friendly to the user to communicate. Look at the use of, and again, this topic is something that I discussed in Conquer Mains as well. Specific to this judgment, right to digital access is also a fundamental right. So where we discuss the ways in which this judgment becomes important. Local languages should be integrated
to make it more accessible.
To make this technology more accessible, user-friendly. And that's the context to this question. Let's look at another question. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In view of the above observation, the Supreme Court explained the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability in India. Constitutional morality is something which is quoted by Dr. Ambedkar. And Dr. Ambedkar made a beautiful statement. He said, constitutional morality is not a natural sentiment in India. It is to be cultivated amongst the Indians. And democracy, after all, is top dressing of the Indian soil, which essentially is undemocratic. These were the words of Dr. Ambedkar. So constitutional morality, which primarily means that every organ, whether it is legislature, executive, bureaucracy, citizens alike, they have to conform to some of the basic principles which are enshrined in the Constitution. For example, liberty, the ethos of the Constitution, liberty, equality, fraternity, justice. And if you recall, two important cases you will have to mention in this case, in this answer. In Naute Johar, where the Supreme Court decriminalized homosexuality by reading down Section 377, the court invoked constitutional morality.
Right.
Because what is your morality may be different from someone else, and may be different from some other person living in a different part of the country. So whose morality will we decide? For example, should homosexuality be decriminalized? You would say it should not be decriminalized because it is against our religion. Some would say against our culture. Some would say against our morals. But we don't have to look at your religion's morality or your culture's morality, whatever it is. We'll have to look at, understand it on the touchstone of constitutional morality, of liberty, equality, fraternity, justice of an individual. And that is how Supreme Court read down Section 377. Then again in another important case, Joseph Shine, 2019, where Supreme Court read down Section 497 of the Indian Penal Code, which spoke about adultery, where two judges, for example, Justice Rohinton Fali Nariman, Justice Chandrachud, Justice Rohinton Fali Nariman said, interesting quotes. He said, Rohinton Fali Nariman said something very, very important. What he said, I forgot, it's a very important statement by, because in adultery, if there is a woman who is having sexual relationship with an outsider, the outsider was penalized, not the woman. Why? Because the logic was woman is always a victim, man is always a seducer. In this case, Supreme Court said, Justice Rohinton Fali Nariman said that this notion of woman always being a victim and man always a seducer, this does not hold true in the contemporary world. And in fact, Justice Chandrachud said, this woman does not lose out on her autonomy, sexual autonomy in marriage. She can explore sexual autonomy relationship outside the marriage. So at best, adultery, Section 497 can be viewed as a ground for divorce, which is a civil case, but it's not a crime against the state. Right. So this is how Supreme Court invoked constitutional morality. But here the focus is on judicial independence and judicial accountability. Even the courts have to abide by constitutional morality of liberty, equality, justice. So you have to give fair justice. For that, judicial independence is very important. So judicial independence, where Constitution has listed down a lot of provisions which provide independence to the judiciary. For example, you hold office till a specific age. You do not hold office during the pleasure of the president. The parliament cannot discuss the conduct of judges inside the parliament unless and until you want to remove a judge from his office. Similarly, the salaries are charged on the Consolidated Fund of India, not subject to the vote of the parliament. The courts have the power to punish people for contempt. You can be removed from your office. But through such a complicated process that till date no judge of the Supreme Court or High Court has ever been removed. So that is independence. But at the same time, accountability. Through the opaque Collegium system, there are question marks about accountability. But there is accountability also through live streaming of the constitutional bench's cases. That is about accountability because Justice Chandrachud said sunlight is the best disinfectant. So bring in more transparency, live streaming, and now the decisions of the Collegium are also uploaded on the website. Recently, the Chief Justice of India, Justice Sanjeev Khanna, he made a declaration that all the judges of the Supreme Court will upload their assets on the website. So this is how judicial accountability has been ensured by the Supreme Court, keeping in mind constitutional morality. So that's a very, very important, beautiful question asked by the UPSC. I think you missed a question. Yeah. Indian Constitution has conferred the amending powers on the ordinary legislative institutions. So Parliament, for example, it has two powers, ordinary lawmaking power and the constituent power. Ordinary lawmaking power means the laws that you can enact on concurrent list, on union list. Constituent power, which means you have the power to amend the Constitution as well. So we don't need a separate constituent assembly to amend the Constitution. But it has few procedural hurdles. For example, if you want to amend some of the federal features of the Constitution, for example, changing the executive power of the union or the state, or Schedule 4 of the Constitution, or make any changes in Schedule 7, or change Article 368 itself, or make changes to the structure of the Supreme Court and High Court, you don't only need special majority in both houses of the parliament, you also need ratification by not less than 1/2 of the Indian states as well. So these are procedural hurdles. Procedural hurdle also is that to amend the constitution, you require special majority in both the houses of the parliament. Yet at the same time, it is also flexible. Flexible in the sense that there are some provisions which you can change in the Indian constitution for which you don't require Article 368. Those can be changed by simple majority. And the constitution says that if you change us, these do not amount to amending the constitution, which means you can make changes through simple majority. For example, abolition or creation of legislative council, providing for the continuance of English beyond 15 years, making changes to Schedule 5 and Schedule 6, reorganizing the state under Article 3, and then making changes to Schedule 1 and Schedule 4. These can be done by simple majority, and that is why various constitutional experts, they refer to Indian constitution as form of flexible rigidity. Although it looks like an oxymoron, can't be flexible and rigid at the same time, right. But that's the beauty of Indian constitution. In view of this statement, examine the procedural. Procedural is this. Substantive limitation is what the Supreme Court invented in 1973 in Keshavananda Bharti, that you can amend any provision of the constitution without altering the basic structure. For example, I'll give you, Sir Chetan sir, a very important analogy. Question before the Keshavananda Bharti case was, is the power of the parliament supreme, that it can amend any provision of the constitution? Right. And Nani Palkhiwala was arguing in the Supreme Court. He talked about something called implied restriction. He said there is something, although not explicitly mentioned in the constitution, because if you read Article 368 or any provision of the constitution, it does not impose any limitation on the power in amending the constitution. But he said there is implied restriction. Implied restriction in the sense, can tomorrow Parliament of India pass a law and convert democracy into monarchy or dictatorship? So can Parliament do that? Which means implied is some restriction. And then he said, can Article 21 be amended to say there is no right to life available to Indians? Or can the Parliament enact a law and say from now onwards, elections would be conducted after 50 years? So can this power be given to the Parliament? Yeah. And then he asked a very important question, last question. He said, if Article 368 gives power to the Parliament to amend the Constitution, can Parliament amend the Constitution and delete it entirely? Delete it entirely. Right. Is that the power available to the Parliament? Or should this power be such a manner that something should be left? You can't change the entire Constitution. Something has to left. A residue has to leave behind.
The soul of the Constitution should
that residue is basic structure.
Right.
The soul of the Constitution, preambular objectives, the nature, rule of law, parliamentary form of governments, independence of judiciary, all these are free and fair elections. All these are part of the basic structure. So that is the substantive limitation on the amending powers of the parliament to change the Constitution. So question has been asked multiple times, but this time the approach is slightly different. Discuss the evolution of collegium system in India, critically examine the advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and that of the United States of America. For example, when this is the topic that I teach in the class, students say, sir, you are talking about both advantages as well as disadvantages. What should we remember? I said, you'd never know what sort of question will be asked in the exam. So every topic, any idea, any issue has to be analyzed both ways, pros, cons, and then you have to give your conclusion as well, suggest some reforms as well. Evolution of collegium system is 1993, second judge's case, also known as Sakara versus Union of India. Supreme Court's Advocates on Records Association v. Union of India, 1993, in which Supreme Court said that appointment of judges is a consultative, integrative, and participative exercise to select the best possible talent to the judiciary. And that is how instead of president appointing judges on her own, it will be the recommendations of the collegium, which is binding on the president. This was reiterated in a presidential reference in 1998. The judgment was authored by Justice GS Verma, the then Chief Justice of India. But then critically examine the advantages. Advantage of the system is it ensures independence of judiciary, because if executive has the final say in judicial appointments, then independence of judiciary would be violated, something that we witnessed in the 1970s when 3 judges were overlooked and Justice A.N. Ray was appointed as the Chief Justice of India. Then again in 1976 when Justice Khanna was overlooked and Justice Beg was irrespective of the seniority. So this system of collegium system is advantageous because it helps in independence of judiciary, which is part of the basic structure. That is why we say that in India, judiciary having the first and the last word on judicial appointments is in alignment with the basic structure, which is judicial independence. It also ensures, because the judges keep on interacting with the members of the bar, they would be the best judges of testing the suitability of a candidate who will be appointed to the Supreme Court and High Courts. The disadvantage also is that it completely removes the role of the executive, which goes against the principles of doctrine of checks and balances. Because Dr. Ambedkar said the most important office under the Constitution is that of the CAG. But the second most important office is that of the judge. But independence of judiciary is very important, but we cannot give power to the judges to appoint themselves and remove themselves because we need to ensure checks and balances. And Dr. Ambedkar said through appointment and removal, we can keep a check on the judiciary. We will give you independence through some various other provisions, which I discussed previously. Their conduct cannot be discussed in the parliament unless and until a motion is brought to remove a judge. They can charge people for contempt. They hold office till the age of retirement, not during the pleasure of the president. So these are the ways in which the Constitution ensures independence of judiciary. But appointment by executive, removal by executive based on the resolution passed by the parliament, this was considered to be a vital cog in doctrine of checks and balances. That is taken away by this collegium system. It is opaque. It lacks transparency. We don't know what judges analyze in a particular candidate, on what parameters is that judge candidate selected and then appointed to the Supreme Court or High Court. So it violates that system. And that is the disadvantage of this appointment of judges.
So, since the question is asking evolution of collegium system, they talk about 3 judges case, njac. That we mentioned for this answer, is it necessary?
Evolution is very important. So discuss the evolution of the collegium system. That is why 1993 judgment, Sakara v. Union of India is to be discussed. The 3rd judge's case, presidential reference. You may also talk about the 4th judge's case, njac, which was against Sakara v. Union of India 2015, which reiterated that independence of judiciary as well as the primacy of judges in judicial appointments is also part of the basic structure. Plus the evolution, contrast it with US. For example, in US, the president nominates a judge. And then this nomination is sent to the Senate. Then there are public interviews, background check, morality check is done in the United States. And then the Senate has to ratify. And then that individual is appointed as a judge. And you're appointed as a judge for your entire life, unless and until you retire or you are no longer considered fit and you are impeached. That is how you compare it with that of United States. Examine the evolving pattern of center-state financial relations in the context of planned development in India. How far the recent reforms impacted the fiscal federalism in India. This question could have been easily answered if you're also following the reforms that have been implemented over the past, whether it is GS2. But there are some limitations. For example, why this question becomes important. A landmark 9-judge bench of the Supreme Court by the majority of 8:1 declared that states have the right to tax industrial alcohol, because previously this right was given to the center. Then again, a 9-judge bench of the Supreme Court, again by the majority of 8:1, ruled that states have the right to tax on mineral-bearing lands, and they have the right to impose tax on the cess, which was cess on royalty, which was previously not allowed in the synthetics chemicals judgment given by the Supreme Court. These 2 judgments, but plus there are some constraints. Constraints in the sense, for example, Kerala government approached the Supreme Court under Article 131, which is the provision under which you resolve the center and state disputes in the Supreme Court, because Supreme Court can interpret the federal and adjudicate federal disputes. There is a limit to the amount of money that a state can borrow, which is subject to your gross state domestic product, and that is the case going on before the Supreme Court. So evolving pattern of center-state financial relations, in the context of planned development of India, now we have become more and more centralized when it comes to the financial matters. So center imposing limits on the borrowing by the states, GS2, which was previously considered to be cooperative federalism mechanism.
Limits on external borrowing, foreign borrowing.
Limits on that. So these are how far these reforms have impacted fiscal federalism. For example, in simple terms, I, as a state government, I want to increase taxes, indirect taxes, because I want to use that money to fund various social security schemes.
Right.
But I can't do that because I need the approval of the GST Council.
Right.
So why would a government of Bihar dictate a government of Tamil Nadu how you should do? Plus, the GST Council's voting rights is skewed in favor of the center. Although 1/3 voting rights is given to the center, 2/3 is given to the states. But even those 1/3 and those who are part of the ruling dispensation, ruling party governing various states. So it is skewed in favor of the central government, and it has weakened the role of the state. But with these two judgments, although these are not reforms, but this is the judicial interpretation, this has strengthened fiscal federalism in India.
Swings the balance slightly.
Slightly, yes. Now it's over to Chetan sir. These were the 10 questions that we had to discuss from Indian polity. Over to you, Chetan sir, for international relations.
So now let's look at the IR questions. There were 4 IR questions asked as usual. So we were talking about the approach to this answer. So first you need to focus on how India's approach towards Africa is different from that of China, or let's say the Western powers. Point out how India has always treated African nations with a great deal of respect. Mutual respect is something that has always been the key pillar of India's partnership with African nations. Maybe in the introduction, you can give a slight context as well. You can point out how India has stood with African countries post-independence to support their decolonization. You can point out how India has been a leader of Global South, bringing up issues related to Africa and lending them a voice at global platforms. And you see a reflection of that today as well when it comes to digital partnerships between India and Africa. And also look at the context in which this question has been picked. In the last few months, PM Modi has completely revitalized India's African diplomacy. PM Modi has visited 3 important African nations. He visited Nigeria, he visited Ghana and Namibia. So these visits is something that has led to this question being asked. Because during these visits, there were initiatives related to building the digital partnership between India and Africa. So what I would suggest is that in the introduction to this answer, you can talk about the mutual respect that India has always shown towards African nations, how we always build mutually beneficial partnerships, and ensure that you point out the global South linkages, the South-South cooperation between India and African nations. And then you can start out with examples of digital partnership between India and Africa. You can refer to the Pan-African E-Network project, which was a brainchild of former President APJ Abdul Kalam. Under the Pan-African E-Network project, India has extended telemedicine and teleeducation services. By using ISRO's satellites, India has set up the required infrastructure on the ground in African nations, with laying the OFC cables, setting up the receiving terminals, connecting African students and African patients with Indian universities and Indian medical institutions. So you can specifically mention E-Vidya Bharati and the E-Arogya Bharati initiative. So this is part of Pan-African E-Network initiative, where India delivers tele-education and telemedicine services, which has been a hallmark of our digital partnership with African nations. And India doesn't gain anything out of it except for the soft power influence. This is where mutual respect comes in. This is where the assistance to African countries, it is driven by the focus on development of the global South. So that shows the vision of India, and this should come out in your answer as well. So make sure you mention the Pan-African E-Network project and how India has been delivering tele-education, telemedicine services. Now coming to the current context, in the body of your answer, you have to talk about India rolling out its digital public infrastructure and UPI into African nations. When PM Modi visited Ghana, Nigeria, Namibia, with all these countries, we have signed agreements to help them in implementing the digital public infrastructure. India's DPI, it essentially constitutes the unique identification number, the Aadhaar, which India has set up, how they have been linked with the mobile phone numbers and the bank accounts, that is the Jandan bank accounts, creating the JAM Trinity. So through the JAM Trinity, India has transformed e-governance, digital governance, and providing for better delivery of government services and welfare programs. So India has become a pioneer in digital public infrastructure. So mention that and how India is essentially exporting our DPI, helping poor countries, developing nations to set up their own digital public infrastructure. You have to mention UPI as well. Ghana has become one of the first African nations to adopt India's UPI. Namibia has also signed an agreement to adopt India's UPI. So these elements have to be brought into your answer. Then also talk about the digital initiatives India has pushed through India-Africa Forum Summit and the G20, because India played a pivotal role at the G20 in 2023 when we hosted the G20 summit to ensure African Union was given membership to G20. This point has to be mentioned because under the G20, there is a digital partnership framework through which India is bringing the top 20 economies to assist African nations to implement digital infrastructure in Africa. So mention these points and you can conclude your answer by pointing out that India's relations with Africa in the digital domain is always driven by mutual respect. It is driven by the objective to genuinely help African countries to develop and solve their developmental challenges and problems. So if you can bring this out, that is more than sufficient because it's a 150-word answer that UPSC is looking for. Next, question number 10. With the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. Elucidate. Now, this question is a thematic, trend-based question. It's not your regular question based on bilateral ties, let's say India-Japan relations, India-Sri Lanka relations. Those questions were always easier to answer. So such thematic questions can be slightly challenging if you're not well prepared, because you need a more holistic understanding of what has happened in the post-Cold War era, how global geopolitics has become more protectionist, more conservative, and countries are now focused on sovereign nationalism through their foreign policy. You need to bring out this evolution which has happened. So your answer should bring out this change. From 1991 to 2016, we saw the era of globalization. The focus was on ensuring free trade and promoting the creation of open borders through various trade arrangements to enable the free movement of people and integration of global supply chains. The focus was on outsourcing. So you look at, be it the geopolitical objectives or the economic objectives of nations, the focus in the globalization era, in the LPG era, under the new public administration theme, was essentially to integrate the global economy, to mutually depend on each other, to help out each other. And that's how China could rise as a global manufacturing powerhouse. That's how countries like India, Vietnam, Philippines, they could essentially provide the goods and services required for the global markets. So we saw the rise of multipolarity. We saw the rise of multipolar institutions, be it the WTO, for example, and how mechanisms were created to ensure free trade and fair trade practices, be it the signing of bilateral FTAs or signing of multilateral FTAs. This was essentially pushing the world towards a more globalized world order. This was the trend from 91, that is after the Cold War ended, all the way until 2016. But something changed from 2016 onwards. In the last decade, we have seen a shift towards conservative protectionism. You need to bring out this change that has taken place. How the world has become more protectionist. And it all started with Donald Trump's first presidency. From 2016 to 2020, Donald Trump's policies, which were more inward-looking, which were more self-centered, driven by his objective to make America great again, it was focused on raising the tariffs, engaging in trade wars. It was focused on bringing manufacturing back into the US, or creating these independent supply chains where US need not depend on China, as it controlled most of the global supply chains at that point. So you need to mention the disruption caused by Trump's policies during the first administration. This is where the global order saw a major shift towards sovereign nationalism. This was followed by repeated shock events, starting with COVID-19 pandemic. COVID-19 was a massive disruption that was caused to the global economy, to free markets. It led to global shutdowns. It essentially pushed countries to look inward, to look after their own interests. And the whole global economic and geopolitical narrative started changing. This is where we saw the large-scale disruption of global supply chains. And the world realized how much they were dependent on China-controlled supply chains. As China went into lockdowns during the pandemic, it disrupted the availability of most essential components, raw materials, and intermediaries. And as a result, production in other countries got directly affected. And countries also realized that as China was rising as an aggressive expansionist power, it was leveraging the economic advantage, its control over global manufacturing and supply chains, and using it for a geopolitical advantage. China was trying to leverage the economic advantage it had to turn that into a geopolitical strategic advantage. So this is where the West, they started essentially delinking their economies, their production supply chains from China, and same has been the case with India. You can even plug in the Russia-Ukraine conflict, the India-China-Ladakh standoff. You can plug in the crisis in the Middle East, that is in West Asia, with regard to the Gaza war. All these events of the last few years has disrupted the free, globalized nature of the global economy. And today, countries are more inward-looking. They are more protectionist, more conservative. Then you come to Trump's second administration. After mentioning the Russia-Ukraine war, the disruption it caused, the India-China tensions, and disruption in West Asia, you finally have to mention the tariff wars and the protectionist policies of Trump's second administration, which has caused chaos in the global markets. And this has pushed countries to become more inward-looking, to concentrate on their own national interests, to become more self-reliant. And this is leading to more closed borders, closure of the free trade routes. The rise of minilaterals is also a result of this. We are seeing a decline of multilateralism and a rise of minilaterals, such as the Quad grouping, the AUKUS initiative, and even BRICS for that matter. These smaller groups have risen to prominence as sovereign nationalism has today taken over global geopolitics and global economy. So it's a very complex topic, and you need to analyze this shifting trends by giving these examples one by one and building a good structure to your answer. Now let's look at the 15-mark questions from international relations. Question number 19. This is a beautiful question according to me. Very anticipated. We have discussed this in our classes. We have discussed this in our YouTube sessions, even in our Conquer Means initiative as well. This is focused on energy security and how India's foreign policy is rooted in our energy security and how our policy towards West Asia is driven by energy security requirements. Let's look at the question. Energy security constitutes the dominant kingpin of India's foreign policy and is linked with India's overarching influence in Middle Eastern countries. How would you integrate energy security with India's foreign policy trajectories in the coming years? For this question, I would suggest you start by explaining India's reliance on the Middle Eastern countries for its energy security. You can talk about how India has been importing 85% of its crude, that is crude oil, from other countries, and 60% of these supplies were essentially coming from West Asia before 2022. That is before the Russia-Ukraine war started, before we diversified our oil supplies, almost 60% of our total oil imports was coming from West Asia. This highlights India's energy dependency on these countries. You can even mention the top suppliers like Iraq, Saudi Arabia, UAE, etc. Then talk about India's West Asia policy. From many decades, it has prioritized energy security for India. We have been balancing our ties between the Shia and Sunni powers, between Israel and Iran, between US and Iran. This diplomatic balance of India is driven by our energy dependency. So once you provide this introduction, then talk about the changes that have taken place. India is no longer as reliant as we were before. For example, after the Russia-Ukraine war started, India today has diversified its oil supplies, and today Russia is accounting for 35 to 40% of our total crude oil imports, meaning our dependency on West Asia has slightly reduced. We are also procuring more oil from United States, from Latin America, from Africa as well. This is the shift you need to mention. But with Middle Eastern countries, our foreign policy priority will always be energy security. And please be careful here. Don't limit your answer only to hydrocarbons. The question is nowhere mentioning only oil and gas. Energy security will also include clean energy and renewables as well. Now, this is where you have to bring in current affairs. You have to talk about the free trade agreement we have signed with United Arab Emirates. Recently, 3 years ago, India, UAE have signed a free trade agreement under which energy security is a top focus. We have signed deals with Saudi Arabia. These major Middle Eastern oil suppliers and energy suppliers are partnering with India today in the field of clean energy, renewable energy as well. From green hydrogen to other transition fuels and other cleaner renewable forms of energy has become a priority as far as the ties are concerned. Then also bring in the recent disruption which has been caused with regard to oil supplies from West Asia, how it becomes a foreign policy priority for us. For example, the Gaza war, the Israel-Hamas conflict, and the widening of this conflict into Lebanon, and Israel-Iran conflict and US-Iran conflict which has occurred recently, how this could disrupt the supplies through choke points such as Hormuz Strait and Bab el-Mandeb Strait. You can even mention the Houthi attacks in Yemen, focused on ships passing through Red Sea route, how it has disrupted oil shipping. So because of all these challenges, all these threats which are present, West Asia remains a priority for our energy security. Our foreign policy towards this region will be driven by these interests. So it is this arc that you have to trace in your answer. So don't just focus on hydrocarbons. Start with that, explain our dependency on these countries for hydrocarbons, then focus on the diversification, focus on clean renewable energy as well, and discuss the challenges that we are facing. How this will remain a priority in our foreign policy, and this will determine the trajectory of the future as well for India's policy towards West Asia. And that will complete your answer. Now coming to the last question, question number 20. Again, a very beautiful question, but the topic is a repeat topic. This question is on UN reforms. If you have seen PYQs, in fact, I took a separate session on PYQs from IR. So there we have discussed UN reforms, and I've told you that this topic has repeated several times. So though the question is different, the way in which it has been asked is different, the topic is exactly the same. The question is asking why UN reforms has been stalled. And the question indicates that the divide between East and West, the divide between United States and the Russia-China alliance at the UN is what is disrupting UN reforms. That is the question. The reform process in the UN remains unresolved because of the delicate imbalance of East and West. It refers to the division within the P5, the 5 permanent members. We have the Western powers, United States, United Kingdom, and France, always aligning together, and the Eastern powers on the other side, Russia and China, which are geopolitical partners and even all-weather friends. So on any important issue at the UN, when you look at the voting pattern, there is a clear division between the East and the West. Now, India believes that we have a right to enter the UN as a permanent member. We even have formed an informal group called G4 with Brazil, Germany, and Japan, and we are very aggressively pushing for reforms of the UN. But these reforms are not happening. Why? Because eventually the decision to reform the UN and admit new members has to be taken by the UN Security Council, which means the P5 countries have to decide because they have the veto. So as per the UN Charter, if any changes have to be done to the structure and composition of the UNSC, if new members have to be admitted, finally that resolution has to be approved by the UN Security Council members, which means the P5 countries have to have consensus. But since the P5 have this extraordinary vote, the veto, and there is a clear geopolitical division between West and the East, they always take a different stand. China, for example, is strongly opposed to the entry of India and Japan as it sees them as regional rivals. Similarly, Germany and Brazil, which are part of the G4, have their own regional rivals opposing UN reforms. So eventually, at the P5, this becomes a matter of East versus West. Then you also take important geopolitical issues, be it the civil war we saw earlier in Syria, in Libya, in Yemen, or the Ukraine conflict, the Gaza conflict, or even the COVID-19 pandemic, or even climate change. On every single global issue, the United Nations has always been divided on these lines, on the lines of East versus West, where US and their allies align together with UK and France, and Russia, China align on the other side. So when resolutions were brought up against Russia for the war in Ukraine, China would protect Russia. Russia would cast its own veto as well. So this issue, essentially, which has divided the P5, has been the primary roadblock for reforming the UN. It is this assessment that you have to bring out in the answer, which according to me is quite easy once you understand what the question is asking. So with this, I would like to bring my discussion to an end. I hope it has been an insightful analysis to help you understand GS Paper 2 and how to look at these questions from polity, governance, and international relations. Later, Ask the Ma'am will be taking a separate session covering the questions from social justice of GS Paper 2 and as well as from Indian society of GS Paper 1. So do watch that session live in some time. But for now, this is it from our side. Thanks for watching. All the best.